I want to welcome you all in honor of this very special Make a Will Month webinar. My name's Kara McDonald. I'm the Director for Philanthropy and Plan Giving at the Seattle Public Library Foundation. I'm joined here by Jessica Carso-Bouillon, the Interim Director of Donor Relations at the King County Library System Foundation. And our special guest today is Christina Corteva, Executive Director of the Snow Isle Libraries Foundation. In honor of August being National Make a Will Month, we decided to spread the love and invite our good friends from Snow Isle Libraries to join us, and we are absolutely thrilled to have you all here.
Thank you, Kara. I'm so happy to join our friends from the Seattle Public Library Foundation and King County Library System Foundation, and want to extend a special welcome to everyone from Snow Isle Libraries who is joining us today. This is the biggest plan giving webinar since Seattle and King County started hosting this in May 2020, and there are nearly 1,000 of you registered today. I do want to acknowledge the land that we are all on, and you saw a slide about that a few minutes ago. I'm so glad you're all here to learn, and I also want you to know that the charitable bequest is one of the most meaningful ways you can support the organizations you love, including your library.
Hello again, everybody. We're thrilled to have so many folks registering and on the call today. I'm going to give you just very brief housekeeping notes to keep in mind. And this is really important since we have so many folks and everybody has a lot of questions to ask, and we really try hard to get to them. First and foremost, we are recording this program. We always do. And you will receive in a few days the link to the recording and slides that Tiffany shares with us. So rest assured, in a few days, you're going to get some informational emails from us, and you can continue to utilize these resources. Now, we have shared with you before, and we just want to make sure that you understand that to share, if you have a question, please be sure that you're putting it in the Q&A button in that section, not the chat. The chat can get really busy with chitter chatter, and then your question will get lost. So please try to do that for us. And then Tiffany is wonderful about monitoring the Q&A when she is speaking, and so that way it also helps her so she understands what questions are coming up. Another really helpful piece is we always end up having lots of similar questions, which makes total sense. Please try to, if you have a very similar question or the same question that you're seeing already typed in the Q&A box, just hit the little thumbs up and that upvotes it, and then we can see how many people are actually wondering the same thing, and we'll really make sure that those questions get answered as at the top of sort of our Q&A section. And finally, a really important piece to all of this too is that so many people have been registering and attending these webinars that it really helps us that at the end, when you sign off of this webinar, you're going to immediately be prompted to a very short but really important survey that allows you to let us know how this experience went for you. These surveys we all look at, we all talk about, we have meetings, and it really informs the conversations and the subsequent webinars. So please take a few moments, and we'd like to sweeten the deal a little bit for you. So, and anybody who does take the survey, you are entered in a drawing for a wonderful bag of books. So it also, I think that's a wonderful prize. And unfortunately, because we're all doing this job, we can't submit. So do it for us. I think that's it for me. I'll come back on at the end to wrap things up and to give you a couple more instructions. Enjoy the webinar.
Thank you, Jessica. Thank you, Christina. I'm going to invite Tiffany and Brian to join us on screen now. And if you have attended any of our webinars before, then Tiffany is a very familiar face. But for those of you who are new, Tiffany Gorton is an estate planning attorney with KHBB Law, who generously shares a wealth of knowledge with us through these webinars. And not to mention, she is a library user and a library lover. And then Brian Lawrence is our Deputy Executive Director at the Seattle Public Library Foundation. And in addition to being my wonderful colleague, he's also a son, a sibling, and a person who has had an experience of estate planning with his family. And he's had to navigate some of the challenging family dynamics that can come along with that. So Brian's here today to share a story and some tips about what his family learned to eventually come to a satisfying outcome. So take it away, Brian and Tiffany.
Well, thank you, Kara. It is a pleasure to be here. And I have to say that through these webinars over the last couple of years, I've learned a lot about estate planning. And I think that I've been able to use a little bit of what I learned about kind of a process that my family went through to help my mom through the process of creating her own estate plan. So I'll give you a little bit of background, and whether or not you have a family situation that's similar to mine, or whether you have a slightly different family situation, I hope that within this story, you can see something that might benefit you. And of course, Tiffany, I feel like, is one of the best estate planning attorneys in the business. And actually, I learned a lot from her over the years to help in making my own decisions about who my family used throughout our process. So a little background. So my parents were married for about 50 years. They have 4 children. I'm one of 4. 3 of my siblings live in Michigan, and I live out of state in Washington. In 2016, my father passed away somewhat unexpectedly. And it was a time where I suddenly knew that we really had to be thinking about my mother's estate. And now that my dad had gone, how do we help and support her through her estate planning process? In terms of like our family composition, so 3 of my siblings have children. I do not, although in my door in the background, you might see my yellow lab Charlotte come charging through at any minute. My siblings, we all have different family compositions. So one of my sister has 1 kid, my other 2 siblings have 2 children. We also have different levels of income amongst our families. So that can sort of influence inheritance decisions. And, my parents had created a will about 25 years before my dad passed away. And a lot had changed. People had gotten married. And knowing that we wanted to help mom kind of get her affairs in order, we kept talking about the need to lay everything out, but nothing was quite happening. And we kept asking mom, like, when do you think we can start this process? And, I started to think about some of the natural barriers that come about when people are planning their estate. And I started to think about, I'm sure my mother didn't want to play favorites with any of our siblings. I knew that my mother was not necessarily familiar with the law. I know my mother knew nothing about probates, wills, and trusts. And amongst my siblings, I was probably the only one that did know because of some of the things I've learned on these webinars. And as my mother aged, she's in her 80s, it became harder for her to understand sort of some of the legal complexities. Even things like navigating the internet can sometimes be a challenge. And it can be a little frustrating for her to sort of figure some of these details out. So it felt like a lot of work, a daunting task, and especially since most of us probably only go through this maybe once or twice in our lives, it was a little overwhelming. So that prevented the process from really starting. So what did we do? We started with a family conversation where I got together with my siblings and identified some of these natural barriers for mom. We came up with a goal, this shared commitment that we had to help mom get her will and all of these legal documents in place over a 6-month period. So we originally met as siblings alone, and we discussed this. How are we going to help her? We got everyone on board with what needs to be done. We knew we needed to find an attorney. We had to develop the key documents like the will, the medical power of attorney, financial power of attorney, and basically the sort of the typical suite that most people have. And we also knew that we really wanted to support mom in the process and make this as painless as possible for her. So as we went about sort of finding an attorney, that was one of the trickier parts of this whole process. So we started asking around. I was in Washington, all my siblings were in Michigan, mom's in Michigan. So we had to find an attorney in Michigan. So all the siblings agreed to sort of ask around. We met every 2 weeks. We were finding that it was kind of hard to find an attorney. Nobody we knew had used an attorney. So having, again, worked with people like Tiffany, I sort of knew what I was looking for in an attorney because I had a little bit of a relationship with her through these webinars. And I literally started looking at Google reviews. I started, just calling around and emailing certain attorneys, asking friends who people knew. And then once I started contacting attorneys, the response was very, very indicative of kind of what the attorneys were like. Some got back to me right away. Some were very upfront with their prices. Some were never responded whatsoever. But right away, I discovered this one attorney who got back to us right away, was very upfront, came from a small firm, and it sort of felt right. So we had an initial informational interview with that attorney. My siblings were invited to attend that. We understood the fee structure right away. For everybody's knowledge, it was about roughly $2,500, and that included the will, the trust, the medical directive, and the financial power of attorney. So it was the whole suite. And then we met with the attorney once we agreed to do the engagement with them. I helped facilitate it with my siblings. We walked through the process together. We walked through the process with my mom. And then the attorney provided us with this really great questionnaire that was the formation for all of the documents that would be built. And from there, the siblings got together and we went through the questionnaire independent of my mom, because our goal was to help make recommendations for her so that she didn't feel the burden of having to come up with the answers to all this stuff on her own. So we tried answering the questions and we tried sort of discussing things so that, again, she would be the ultimate decider, but as a family, she knew that we were all 100% supportive of one particular plan. And that actually worked out really, really well for us. We talked about her charitable plans. We talked about kind of our inheritance and how that would work with the grandkids. And we made it really easy for mom. And then, from there, the attorney drafted the documents. Again, the kids reviewed everything for her to help her. We all collectively said, Mom, we agree that this is a good set of documents. We liked our attorney. And Mom was able to feel really comfortable signing off on what was created. And I will also say that there was a bit of a ripple effect because this process was so easy for Mom that both of my sisters end up using this attorney to update their plans. Countless number of friends have now used this attorney. And so it was much easier for Mom. And it was also, it was much less difficult than I would have ever managed. So I am going to share, just quickly summarize my tips, and then I'm going to give it to Tiffany. So let me know if you're seeing my screen. So again, my planning tips are you seeing my screen, Tiffany?
I can, yep.
Okay, all right. So number one, think about what is preventing you from getting your affairs in order, whether it's costs, unknowns, fear of decisions, finding a professional, et cetera. Write those down and think about them, because I think they're really easy to overcome once you have a good understanding of what might be holding you back. Set a realistic deadline. For our family, we said we'd like to get this process done in 6 months, and we agreed to meet regularly, like every 2 to 3 weeks over Zoom, to get this figured out. Get the family involved. Be aligned around the same goals. I think estate planning sort of sounds scary, but once you talk about it, it can be an incredibly supportive way to go through that process. And of course, our goal was to ultimately complete the project, so to speak. My next tip is to find a professional that gives you a good feeling. So in our case, I talked to several attorneys. One of them really stood out in terms of the reviews and how that particular person responded to me, and it ended up being the right decision for our family. I like to say that most professionals have a guided process, and Tiffany has this as well. Like, once you go through this questionnaire, it just becomes, yes, it can be a little bit of work to come up with the some of the questions. And once you get into like building a trust, there's some financial stuff you have to put together. But the guided process that the attorney created for us was actually super easy.
Mhm.
Another tip is to divide up tasks. In my family, everyone sort of got a role. So because I'm in Michigan, I facilitated the entire estate planning process for my family. My sister got the medical power of attorney. Another sister was the financial power of attorney. My brother is the executor on the will. So just a way to sort of divide up tasks. And then set the stage for the ultimate decision. We went in saying, Mom, this is your decision to ultimately come up with this, but we can be supportive to you by making recommendations so that you know that we are all on board with your decisions. And lastly, like if you have a good process, it is the most rewarding thing you can imagine to be able to help others through this process. So if you do have a good attorney, spread the word because again, this is August is Make a Will month, and if you can make that your will and get the peace of mind knowing it's done, it's pretty powerful. So that's my story.
Thank you so much, Brian. That's super helpful. And kind of the tips that you've provided. Brian and I had a conversation prior to setting up this webinar about his experience, and being able to hear from another person who's not a lawyer, who's gone through it and kind of worked through that as a family, et cetera, is so valuable and has been so valuable to me. So thank you personally for sharing that.
You're
but
welcome.
Just thinking about those things, it is not unusual to have those kind of roadblocks. It feels really daunting. To your point, oftentimes this comes up once, maybe twice in life when you're kind of working through these things. And even thinking through the questionnaire, my questionnaire is 8 pages. That's not huge. A lot of it is, listing yourself and your kids and your grandkids. So it's not, really difficult questions, but just thinking about that sitting on the corner of one's desk can feel like Everest sometimes.
Absolutely.
And so I think that, whether you have siblings who are involved and helpful, which you're very fortunate to have, and your mom's very fortunate to have the group of you kind of working together to support her. That was, I know, invaluable to her. Or you're, a single person with no siblings and you're trying to figure it out on your own. It's one of those things where kind of thinking through each of those bullet points really apply universally. And I think Kara made that point in the Q&A, if that's something that, can apply to everyone. And it really is, because, we're all humans at the end of the day. We're all, wanting to make things as easy as possible for our loved ones. And that's really, the reasoning for foundational planning is to set everybody up for success one day when we're no longer here. And being able to kind of take those bite-sized pieces and think through it, I think is incredibly valuable. So thank you so much for sharing that. I really appreciate it.
All right, I'll let you get to the webinar now. Thank you.
Thank you. Okay, so I'm going to share my screen and kind of moving forward to kind of creating and maintaining a foundational estate plan is what we're going to continue talking about. But as we're walking through the discussion regarding kind of some of the things to think about in advance of making plans that we're going to talk about, the documents, wills, durable powers of attorney, revocable living trust, taxes, kind of all those topics that we're going to discuss here in a few minutes together. Be thinking about some of those things that Brian mentioned in terms of the process that, as how he and his siblings approached it. And as we're thinking about these various items to consider, kind of think about those for your own life. And this is, of course, being recorded. My slides are going to be shared, so you'll be able to come back. You don't have to, furiously write notes. But this will, I hope, be a really good resource to everybody out there, regardless of shape, size of family, estate, et cetera, just to kind of think through. And August is Make a Will month, so having everybody get their ducks in a row. And another thing that was really encouraging about Brian's comments is the fact that his sister or his siblings, some of his siblings, ultimately, this prompted them to set up their own plans and family friends, et cetera. because at the end of the day, a huge gift to folks that you can leave as a legacy, even if it's not a huge monetary value, is really just setting up your loved ones, family and friends, and or organizations that you care about, setting everybody up for success, giving them a clear roadmap, and making sure your wishes are carried out. So with that, I'm going to share my screen. So I have some slides to share. So the first thing that we're going to talk about just for a moment, I promise this entire presentation from here on out is not going to be about taxes. But one thing to consider, as our friend Benjamin Franklin said, there are two things in life that are certain, and that is death and taxes. So we're going to talk about both for a little bit today. But in terms of thinking about estate taxes, because this is something that folks oftentimes, whether this applies or not, this is something that folks are thinking about. They've either read an article in the news, or their neighbor was talking about their parents' estate, something that had to do with estate taxes. So to kind of demystify it, what is the estate tax? Different than how we pay our income taxes. What an estate tax is it's a one-time transfer tax that's due when a decedent dies, based on the decedent's overall asset value, if those assets reach a certain threshold level. As I was saying, in terms of what we do know about the federal estate tax, at the end of 2025, if no proactive legislation happens, then that number is going to drop from that almost 13 million down to 5 million adjusted for inflation. So somewhere in the neighborhood between 5 and 6 million will be the exemption amount per person at the federal level. So until then, we have this 12,920,000. It gets adjusted each year for inflation. So Washington is one of the states that has its own estate tax. And as you can see, the exemption amount for Washington residents is significantly less than the federal exemption. It's 2,193,000, which is still a very large number. But if you think about real estate prices in King County, what having a life insurance policy, et cetera, all those assets are counted toward this estate value. And so the Washington state estate tax does actually affect a lot of individuals. So this is something to be cognizant of. And I just want to mention it to kind of flag it for everyone. As I promised, we're not going to talk about taxes. I'm not going to put everyone to sleep here in the next 45 minutes. But I wanted to make sure that this is on your radar, because as you're thinking about what do I want to talk to my estate planner about, or what do I need to be thinking about in advance of preparing estate planning documents, estate taxes and whether or not you fall into the category of assets rising to that threshold level of 2,193,000 for Washington, or that 12,920 for the Fed, that's something that should be on your mind, just in terms of something to consider, because there are some tools that we can use to plan for minimizing estate tax exposure if that's something that would affect your estate, your family. So just to kind of show what the estate tax numbers look like, in Washington, it's a graduated rate between 10 and 20%. As you can see, it depends on the amount of exposure there. So the amount over that 2,193,000, that equates to kind of where you fall in terms of the percentage that's applied. At the federal level, it's between 18% and 40%, again, graduated, but it gets close to 40% relatively quickly at 1 million and up, versus the kind of, it's a more compressed set of circumstances than at the Washington state level. So importantly, thinking about taxes as one thing that could be on your mind as you're thinking about your estate planning, or how to approach your estate planning. And when you're considering that, remember the way that the estate tax works is, this is not something where, as an individual, if I had a taxable estate, I don't send a check to the Department of Revenue or to the Department of Treasury, to IRS. This is something that one day when I pass away, there are, of course, an unlimited marital deduction. So if you're married and assets flow to a surviving spouse, they're not going to be taxable. Charities are, gifts to charity are exempt from that amount. So there are some kind of general mechanisms for who you designate as beneficiaries that can reduce or eliminate estate taxes. But just to be clear, this isn't something where I write a check for my own estate taxes, or in my case, my assets would flow to my spouse. My spouse is not going to be in a position of having to write a check. This is typically what comes into play after a person is deceased, or after both spouses are deceased, or if it's a single person at their death. Then we look at all of the assets that were in existence: real estate, life insurance, retirement accounts, investment accounts, bank accounts, all the assets, and say, does it rise to this threshold level? And do we need to file an estate tax return? And could there be some estate tax due? So that is kind of the estate tax in a nutshell, just so that you have it on your radar again and are thinking about it in case it applies to you. You're thinking about it as you get ready to set up foundational estate planning documents. So some additional things to be thinking about. And again, we're going to talk more about the documents here in a few minutes. But as you're thinking about how to prepare and kind of preparing yourself, we saw the bullet list that Brian shared of kind of some of the roadblocks that some of us encounter, or many of us encounter. And these are some of the things that you should be thinking about, or at least considering in advance of saying, okay, I'm going to sit down with my my organizer here, and I'm going to make a detailed plan as to how to proceed. These are just some issues to kind of be mulling over, because these are the things that if you work with an attorney, most likely they're going to want to talk to you about these things at the outset. These bullet points come straight from my initial questionnaire of things that I want to talk to clients about at the outset. So very similar to what kind of other attorney processes, as well as if you're working on this on your own, things that you can be thinking about to kind of streamline the process and make it as efficient as possible. So first, if you were to become incapacitated, who can you rely on to take care of your finances, your health care? If you have minor children, making sure that you have somebody on deck, so to speak, to be able to assist with those circumstances if they were to arise. Similarly, if you were to have a terminal illness or in a permanent unconscious state, do you want heroic life-saving measures? You want those continued, or do you want them removed? We think about this in terms of end of life, and that comes into play. We'll talk a little bit more about a durable power of attorney and appointing a healthcare agent, but just thinking about kind of end of life decisions and who you would want to step in if that circumstance arose. Similarly, following death, do you want to donate your organs, your tissues, your entire body to science? Do you want to donate organs or tissues only to individual human recipients? Or are you comfortable with medical or science research? Is that something that's important to you? Thinking about those things, what you want done with your human remains. Similarly, do you want to be buried, cremated? In Washington, we're real pioneers. We have human composting, we have alkaline hydrolysis. So are there beneficiaries who should go into a trust for his or her benefit? This is something that's important. We oftentimes think about this if we do have minor beneficiaries in our lives. So family members, children, grandchildren, nieces, nephews, family friends, any minor that may inherit, considering utilizing trust language under a will or trust language under a revocable trust for the benefit of that minor is very important, just in terms of making sure that they're set up for success with any amount that they're going to receive from your estate. Beyond kind of the age of minority, thinking about young adults, that college age, or maybe 21 and over, as folks grow and age, and presumably, hopefully, become more financially responsible and are able to manage assets for themselves. Are there various stages that you think it would be appropriate for those individuals to receive assets, or should they remain in a trust for their benefit? Kind of aside from kind of general minority up through young adulthood, if you have a beneficiary in your life who is receiving government benefits due to some type of a special need, wanting to make sure that by the receipt of the generous gift from you, they don't lose their benefits. There are certain types of trust that you can build in to a foundational plan to ensure that none of those government, Medicaid, or similar benefits are disrupted for that individual. Do you have a beneficiary that struggles with, addiction or alcoholism, something like that? What you're really thinking about here in terms of the important people in your life is there something about a gift that this person may receive that I want to make sure that they are set up for success because of X? So because they are a minor, or because they have this circumstance in life, just making sure that you're thinking about kind of it's very personal to think about the people in your life that you want to benefit and how to best benefit them. So considering if you do have any of those circumstances, how to build in tailored benefits for those beneficiaries. Thinking about, following death, who can you rely on to administer your estate? So this person is often referred to as executor, administrator, personal representative. That those terms are used somewhat synonymously, but who would step in and gather all of the assets, make sure that your final income tax return was filed, make sure your estate tax return is filed if that's something that would affect your estate. If you kind of rise to those threshold levels with assets that we talked about at the outset, and then ultimately who would distribute assets for the benefit of your beneficiaries according, to your roadmap, according to your will, or according to your revocable living trust. Who would be the person that you would select? And that can be one individual, that can be co-executors if you want to include more than one person, and that makes sense given your circumstances and who the people that you would choose, if that makes sense for you. Similarly, I have a lot of clients now who are asking me, in spite of having, children or other family members or friends that they could call upon to serve in that role, a lot of folks are thinking about using a professional fiduciary. I tell clients all the time that being an executor is not necessarily an honor, it is a job. And so making sure that it's viewed through that lens, and thinking about, yes, it could just be my oldest child, or it could be, a family member or a friend, but there are also resources, particularly in our area, in the Puget Sound area, where there are professionals who serve in that role to ensure that everything is done appropriately and no one is overburdened in terms of, a family member or friend. So thinking about who would be a good person or organization to serve in that role. Do you have a plan for digital assets? Does somebody know where those assets are, where they live, where the passwords are? Thinking about kind of some of the obvious stuff that comes up there is Bitcoin or logins for your online banking, things like that, but also Facebook or other social media, email, your Gmail account. Those different social media or email or online digital assets, as they were, have come along with their own contract. You probably clicked agree, and then you set up your iPhoto account or similar at the outset, probably years and years ago, and haven't thought about it since. But sometimes it can be important for family members to be able to access those photos, or an individual can say, you know what, I just want everything to go dormant. I don't want anyone to log into my accounts after the fact. And you can tailor language under the terms of your roadmap, your will, or your trust to provide for access or limited access to ensure that your wishes are carried out there. And then finally, and this is important both for, while we're living and then thinking about one day when we're gone, is how will your fiduciary, so how will your executor, or how will your agent for finances or your agent for healthcare, how will those people or those individuals find your asset and liability information? If you become incapacitated and need assistance with managing your finances, how will they know who is supposed to be paid each month, where you bank, who you have a loan through, et cetera? Thinking about all those things that we manage on our own now, okay, I bank at, B of A, I have my investments with Morgan Stanley, I, have a mortgage with also with the Bank of America mortgage department or whoever, which those are all sold so frequently that they often change. But thinking about kind of where all your stuff is and thinking about how you could make sure that if somebody does have to step in and help you, because you're experiencing some, level of incapacity in life, or one day when you're gone, that your executor can step in and say, okay, here's where all the assets are. Here are the creditors that I need to make sure that I give notice to. How are they going to find those things? So, it can be as simple as having a list of here's where I have my accounts and my assets. Here are my, debts that I owe, and, just keeping it in your filing cabinet or keeping it with your important papers. Oftentimes folks will think about, where do I store passwords? Because we do have so much of our lives that exist online, and making sure that anyone who steps in to help us or steps in to administer our estate can easily access those things. There are various apps that you can use to store passwords. So it's not just, a wall full of sticky notes like it used to be. So something secure, but just be thinking about all of those things and how that can play into and inform your overall plan. So moving on to we have a lot to think about. We have some things to think about in terms of what feels like barriers to us to getting started, and what things that we want to think about in terms of how to best design our plan and who our beneficiaries are and who our people are. So thinking about those things, but we also want to look at moving forward. What are the documents that we're actually going to use this process, use this information to set up? So let me see here. And just I'm going to take a couple of questions here. How important is it to inform those in my will of what they will be receiving? That's a great question. Thinking about your beneficiaries during life, it's very important to make sure that if someone is going to serve as guardian for minor children, or a similar position like that, making sure that they're aware that they've been appointed, or they're going to be appointed should the need arise. That's important. You don't necessarily have to share your will with anyone prior to death, because it's changeable. It's something that you can, change throughout life. And so any beneficiaries, charities, I think that is typically important to make sure that they're aware that you're remembering them in some way as kind of a legacy gift like that, because they like to oftentimes be able to thank you during life, and kind of be able to track those things. But individual beneficiaries, again, because you can change that document throughout life, and who knows what the assets are going to be at the time that this actually comes to pass. You don't necessarily need to share that information with anyone. Hoping to get some information regarding solo agers who don't have anyone to ask to be administrator. That's a great question. That is, as I mentioned, a lot of clients are looking at utilizing a professional fiduciary. And that doesn't necessarily mean big bank trust department. I mean, it can, if that is appropriate for your plan and your circumstances, but there are a number of small and solo outfits in our area where the individual is maybe a retired attorney, or it's a part of their practice, or they are, they have a small group of individuals that serve as agent for finances, trustee, executor of estates, and they typically charge an hourly rate. And they have varying hourly rates for, the rate that you're using to clean out the shed, for example, and kind of get things, tangible personal property all sorted out, is different than, a rate that would be charged for working with the accountant for the last income tax return and some more substantive kind of tasks. But there are a lot of resources for that in our area. And so that's definitely something that folks are using more and more these days. Okay, so thinking about kind of some of these documents, I always tell clients that I think the durable power of attorney is the most important piece. So in terms of kind of the overall plan, this is part of any foundational plan. And the reason that I say that this is most important is because it takes effect while we're still living. This is a document that says, I'm going to appoint this person as my agent for finances, this person as my agent for healthcare, and it really puts somebody on deck, so to speak. So if something were to happen to me where I had an accident, or I was 102 and I was tired, or, oftentimes we think about later in life, most of our families are affected by, Alzheimer's or dementia. It can be circumstances like that where you need someone to step in and help with finances, make sure the mortgage is paid, make sure the taxes are filed, etc. Similarly, somebody to step in and make sure that our healthcare is managed in the way that we would do it if we had the capacity to do so. Making sure that we're visiting the dentist regularly, that we are seeing, any specialty providers, seeing our regular provider, ensuring that, our medical care, our healthcare is managed in the same way that we would have managed it during the years that we were able to do so. And so thinking about this can be end of life decisions. This can be thinking about how life support if we're terminally ill or in a permanent vegetative state. But this can also be a little bit of a longer term position where, we're simply aging and maybe we need, a little bit of extra help. And that can be for a number of years. Anecdotally, I'm from Michigan. Brian and I have that connection. We didn't know each other there, but that's where we're both originally from. He mentioned his mom is still there and his siblings. So my family is also back in Michigan. I'm an only child. And so working on things for my own parents, particularly mom, I'm helping her, with her monthly banking and, making sure the bills are paid and things like that. And, luckily we live in a day and age where those things can be managed even, remotely or from afar. But it's something where, that's something that I've been working on for a couple of years with her and will continue to do so. So it's not always somebody to make end of life decisions. It can be, but you just want to think about it in terms of it could be a longer term position, but making sure that that person can manage, healthcare in the way that you would want and finances in the way that you would want in the event that you don't have capacity to do it. And that can be one person, that can be two people together, if that makes sense for you. It can be a professional, and it can be a different person for finances and healthcare. And oftentimes it is. As Brian was pointing out with him and his siblings, each person got a role. And one person is serving as the agent for healthcare for their mom in the event that she needs help there. Similarly, there's somebody serving for finances for her if she needs that help down the road. And so just thinking about who in your life makes sense for each of those individual roles. And again, remembering that there are resources for professionals who serve in those roles, if that makes sense for you. So we have a lot of different options there. But that's the durable power of attorney piece. So again, putting somebody on deck, so to speak. And what needs to be, what's required for a validly executed durable power of attorney? It needs to be signed, dated, and acknowledged before a notary or attested to by two witnesses. And particularly if it's going to have anything to do with real estate, meaning if this person would have the authority to, sell a house, things like that, in the event that, that need arose, then it's going to need to be notarized. And importantly, it has to be signed in the presence of the principal. So if I'm making my durable power of attorney, I call my witnesses over and I have my notary there, I need to sign in their presence. They need to see me sign, and then they're attesting to having seen me sign, so to speak. So this is a cat meeting with their estate planning attorney, and he's getting 9 wills prepared because he's got 9 lives. So the second document that we think about often is the will. Excuse me. And that's important. This is something that often comes to mind, and most Washingtonians, probably 9 out of 10, are very well served with this as their primary financial planning tool. So you set up a durable power of attorney because that takes effect during life, but then you also think about what's going to take effect at death, what's going to direct who's my executor and who my beneficiaries are. And that can be a will or a revocable trust. And we're going to talk about both, but most of the time a will makes sense for most folks that are Washington residents. We'll talk about why in just a minute. But basically, this is a document that takes effect at death. You can change it during your lifetime, so it's completely revocable, it's changeable, and it provides a roadmap for who you want to serve as your executor, who's gonna be in charge of gathering assets, paying creditors, and filing taxes and making distributions to your beneficiary. And it provides that roadmap of who are your beneficiaries, who's going to receive this distribution. Are there going to be trusts built in for minors, or to ensure that, you know, somebody with some special needs benefits is going to be able to continue to maintain receiving those? And all of those things can be built into the will. It doesn't necessarily have to be some sort of a standalone trust. It can be built into your will and not take effect until after death. And what happens at death is the will gets filed with the court at that time, and then a probate proceeding may or may not be opened depending on what assets are there. And I am going to talk in a few minutes briefly about what probate looks like. Sometimes people think that that's a scary word. It's not as onerous in Washington as it is in some other states. For example, California, folks want to avoid probate at all costs. It's very expensive there, and it's a clogged system. It takes a very long time just by its very nature. In Washington, that's not so. That's why I say that most folks are well served utilizing a will here, because our probate process is not particularly onerous like it is in some other states. And what probate really is, I'm gonna kind of jump ahead a little bit, is a court supervised process of settling a deceased person's estate. So basically, you can think about it as kind of closing down a business, so to speak, but you're kind of closing down the financial life of someone. So you're there, your executor is appointed, they gather all of the assets, they find your list of where all your bank accounts, where your investment accounts are, do you own real estate, do you have life insurance, a life insurance policy, and then they're appointed and they say, okay, I need to file the final income tax return. I may or may not need to file an estate tax return depending on the size of the estate. I need to make sure that I give notice to creditors so that if there's any debts out there that this deceased person had, that those people are known or are notified and can make their claim if they have a valid claim. And then ultimately making distributions to the named beneficiaries. So again, this is just kind of what that probate process involves. It's what is that executor or administrator, personal representative? What are their jobs, so to speak? And importantly, thinking about, well, okay, this is probate, this is the probate process, but what is outside of probate? So non-probate assets, going to be assets that are titled joint tenant with right of survivorship accounts. If you have a community property agreement that governs assets, property held in trusts, life insurance policies, if they have a beneficiary designated on them, transfer on death or pay on death accounts. Those will all pass via contract, so to speak. So they're not necessarily part of the probate. They are going to be included in the big total of assets for estate tax evaluation purposes, but they might not necessarily fall under the terms of the will. And so that's one thing to think about as you're kind of preparing your overall foundational plan. You want to make sure that if you do have some of these assets, life insurance or various, investment accounts, retirement accounts, you want to make sure that your beneficiary designations match up with what your intention is, and two, make sure that one doesn't kind of run amiss of what the will says. So you want to make sure that you're thinking about all of your assets in kind of a big picture and how you want things to be distributed to beneficiaries. And you can update your beneficiary designations as in conjunction with kind of setting up your will and your durable power of attorney, or your durable power of attorney and your revocable trust. So kind of big picture, you want to make sure that all of your assets are thoughtfully directed to where they're going to go, to which beneficiaries they're going to go to. So again, the probate process is something that comes up after death, utilizing the will gets filed with the court, and then the executor is able to move through kind of making sure that they gather the assets, notify creditors, and then ultimately make distributions. And so what's required for a valid will? Well, it has to be in writing. and it's going to have to be signed by the testator, by the person making the will. So for my will, I'm the testator. For your will, you're the testator. So make sure you sign it, and that it's signed by 2 competent witnesses, meaning they're over 18 and they're able to testify, I saw Tiffany sign her will. And again, they have to sign, everyone has to sign in the presence of the other. So I sign it, and then my 2 witnesses here are sitting across the kitchen table from me, and they sign as witnesses. Some states have what's called a holographic will, which is a will that's drafted in my own handwriting. That is not the case in Washington. So simply by the nature of drafting your own will in your own handwriting doesn't make it a valid will. What makes it a valid will is that it's in writing and it's signed by the testator and signed by 2 witnesses. So that's an important point, because sometimes we run into circumstances where a handwritten will comes out after somebody is deceased, but it's not executed under the statute, and so it's not going to be treated as a valid will. So we mentioned that a will can be one of the primary estate planning tools, and the alternate, so to speak, is the revocable living trust. Now, these 2 function somewhat similarly in that they do provide a roadmap for beneficiaries, where assets are going to flow one day when I'm deceased. But a trust is something that is sort of active during life, in that we set it up, we draft it, we execute it according to the statute, and then we change title on assets. So for example, if I set up a revocable living trust for myself, I'm going to title my house in the name of the trust. So instead of owning the house as Nick and Tiffany Gorton, we own it, that's my husband, we own it as Nick and Tiffany Gorton, trustees of the Nick and Tiffany Gorton Trust. Doesn't change anything from my day-to-day life or how I, claim my mortgage interest deduction or maintain insurance on the house, etc. It doesn't save any taxes in any way. But what it is kind of a will substitute. It's a way that, it's just an alternate type of roadmap, so to speak. And it's just funded slightly differently than a will. Remember, a will doesn't take effect until we're deceased, whereas a revocable living trust, you draft it during life, and then it's effective during life, and you can put assets in it during life. Again, it's revocable, just like a will. You can change it, you can completely revoke it during life, but it functions slightly differently. One time that this does come up, where I mentioned before that most Washingtonians are very well served with a simple will, is when folks have real estate in another state. So I have a lot of clients who moved to Washington from California. And so maybe they have an existing trust. So we'll look at that and say, okay, you're keeping real estate in California, or you have real estate in Oregon, or wherever, some other state that's not Washington. That is typically when I say, you know what, a revocable living trust is going to make the most sense here, because what you want to avoid is having a Washington probate and then a California probate, an Oregon probate, all these, probates in various states. Some clients will say, you know what, Tiffany, I sold my place in California, but I do have this revocable trust that's in existence that we signed, 10 years ago. And I say, you know what, if you're comfortable with that, it's not broken, so no reason to fix it. We can do an amendment and restatement so that it becomes a Washington trust, and then you don't have to change your whole plan, so to speak. Some folks will just say that they're more comfortable with the trust because that's, they administered one for their parents. Any number of reasons like that are pretty simple are just fine for this kind of preference. It's your plan, so you are you're the decider, so to speak. But the time that I do recommend it for clients is when there is that real estate in other states, just to ensure that you're not having to kind of do multiple steps in multiple places unnecessarily. So with that, those are kind of the primary tools. The one thing that I want to mention in our last minute together is when to consider updating your plan. So I hit a couple of them already. If you do move to Washington from another state, consider it. If you move from your home state to any other state, consider updating your plan, at least thinking about, reaching out or thinking about the possibility of updating, just to make sure that there's nothing there that, is left untied, or all your I's are dotted and T's are crossed. So if you make a move from another state or to another country, from another country, another jurisdiction, so to speak, weddings, babies, funerals, liquidity events, receiving a large inheritance. So any really big life changes, you know, your children graduate from high school, they graduate from college. I joke that the first estate plan that I worked on after law school was for my in-laws. And I told my husband, it's a good thing I updated your parents' plan because you would have had to go live with your Aunt Kathleen if something happened to them. Well, that's not entirely true. But the point is, they hadn't updated their plan since, you know, they set it up in the 70s when their children were minors. And now, you know, life looks very different. They have grandchildren and in-laws, etc. And so anytime you have kind of a big life event, so when somebody gets married, particularly you, or, you know, the opposite of that, if there's a divorce, if you have a child or, you know, multiple children, if somebody passes away, if you sell a business, or you have a significant increase in wealth, or you know, receive an inheritance, etc. So kind of those big life events, I always tell folks, at least think about are there things that maybe affect my plan? So with that, thank you so much. I'm going to stop sharing and turn this back over to Jessica and
Thank
Kara.
you so much, Tiffany.
And
A
Tiffany,
huge thank you from us. As always, first and foremost, your information is, I'm always blown away. I'm learning a great deal, and I know that our attendees are as well, but today especially, we're all wondering what happened. We sincerely apologize. You know, there's lots of weirdness in the world, and who knows where this came from in terms of Wi-Fi's being down. So thank you so much for sticking with us. We have recorded this session. Tiffany is wonderful about sharing her slides with us, and then in a couple of days, you will receive emails from us with the recording and with the slides. There was a lot of questions today in both the chat and the Q&A about previous webinars. All of them are in the links. We will put that in the email as well. I tried to get them in. I know Kara was as well in the chat box to give you the links, but we'll also include those. Just a very, very quick reminder that as you're signing out, if you do take 2 seconds to take the survey, we promise it is very helpful to us. And you will be entered in to win a bag of books if you do that. So thank you so very much. Christina, I'll be very happy to turn it over to you.
Thank you, Jessica. I also wanted to thank everyone again for staying with us despite the technical difficulties. And as someone wrote in the chat, technology is great when it works. So thank you again. Please note that we'll be sending a follow-up email with the webinar recording and slides. So look for that soon. And finally, just a reminder that the charitable bequest is one of the most meaningful and significant ways for you to support the nonprofits you love, including your library. Please let us know if you're including us in your plans so we can thank you and ensure we can fulfill your wishes. If you have any questions or would like to continue this conversation, please reach out. Our contact information will be on the screen shortly. Thank you again for joining us today and enjoy the rest of this gorgeous day.
thank you. Thanks, everybody.